We're now going to move to our second panel, and
Take off bars.
while they take their seats, this idea of forced treatment versus constitutional rights has always been a tension that we've had in our criminal justice system. There was an issue that came up earlier this year that you may have read about involving the implementation of a chronic inebriate court, which was a court that was supposed to treat individuals who were suffering from long-term alcoholism. And the court was set up in a way where individuals were not being arrested for a crime, but instead were being jailed for contempt of court as long as 120 to 150 days in jail. And my office, when we learned of this court, we were not involved in the creation of it, challenged it because we believed that it was unconstitutional, because you were not charging people with crimes and you're jailing people for essentially contempt of court when legally they hadn't failed to come to court, because in most of these cases they had simply been served with citations. So a legal challenge was filed, and the court was found to be unconstitutional by the California Court of Appeal. But it still left a question, and I think one of the columnists, Chuck Nevius, raised this in one of his columns, how do you deal with the tension between constitutional rights and wanting to provide treatment to individuals who need it? And so out of that came the idea for this panel, and actually action behind this panel as to what to do. Now, we do have a lot of collaborative courts in San Francisco. We have a mental health court, we have a drug court, domestic violence court. But San Francisco is sort of at the cusp of considering what measures to take in serving individuals who suffer from mental illness and also individuals who suffer from drug, substance abuse, chronic inebriation. So it's with great pleasure that I introduce our moderator, John Diaz. John Diaz is the editorial page editor for the San Francisco Chronicle. He has followed this issue very carefully, and I'm very pleased to introduce him now. John?
Thank you very much, Jeff, and good morning and welcome to our panel this morning on forced treatment and constitutional rights. Can they coexist? I am John Diaz. I'm the editorial page editor of the San Francisco Chronicle, and I'm going to be moderating this morning's discussion with our distinguished panel. Forced treatment, as Jeff noted, is one of the most contentious issues in the field of mental health. As you will see from our discussion, there are informed and passionate views on both sides of this issue. For more than a decade, there has been a very vigorous debate in many areas of the state on whether and how to implement Laura's Law, which, at the discretion of each county, allows for court-ordered assistant outpatient treatment. The 2002 law was named after Laura Wilcox, a Nevada County mental health worker who had been shot to death by a man who had refused psychiatric treatment. As of today, Nevada County remains the only one of the 58 counties to fully implement the law, although there has been a pilot program in Los Angeles County, and several other counties appear on the brink of considering it. Today we will be exploring why counties have proven so reluctant to adopt Laura's Law. What are those constitutional and very practical concerns about forced treatment? What are the causes and the consequences of allowing people to refuse treatment? We are so fortunate to have with us today a very distinguished panel of people who have a deep knowledge of the subject, in some cases because of their professional endeavors, in some cases because of a very serious personal experience, and in some cases, both. Let me introduce them. Karen Chien is Attorney Manager of the Mental Health Unit for the San Francisco Public Defender's Office. Candy Dewitt is a Laura's Law advocate whose son battled with mental illness. Dr. David Kahn is a substance abuse treatment expert for the Veterans Affairs Medical Center. Denny McLagan is Associate Director for the Serial Inebriate Program for the City of San Diego. Greg Suhr is San Francisco's Chief of Police. Dr. Gary Tsai is a psychiatrist and Laura's Law advocate. And finally, Eduardo Vega is Executive Director of the Mental Health Association of San Francisco. Well, let me start by posing a question to Karen Chien from the Public Defender's Office. Karen, how about if you start by giving us an overview of how the city handles this conflict between treatment and civil liberties?
Yes. An involuntary hold starts in San Francisco when a peace officer or a clinician makes a determination that the person is, due to a mental disorder, is a danger to others or danger to self or gravely disabled. And gravely disabled means that person does not have the ability to provide for basic needs such as food, clothing, and shelter. And the legal representation starts in most cases the first 3 days of the involuntary hold during the initial psychiatric evaluation. And then the legal representation also continues with if the person is asked to be stay or detained for further treatment up to 14 days. And during this phase, the attorneys will represent the clients about whether or not they will have to stay on this hold, whether they have to take medications. If a person, at the end of the 14-day hold, it's found that may need further treatment, the person may be subject to a conservatorship under the Lanterman-Patras Short Act conservatorship provision in our California Welfare and Institutions Code. And legal representation continues in all stages at the initial establishment of the conservatorship and post-establishment of the conservatorship, such as objection to placement decision by the conservator, objection to the conservatorship, and also propose medical and psychiatric treatment. One of the things that in San Francisco, that up to 2012, we are one of the 3 counties that consistently offers judicial review when there is a recommendation to take away someone's right to refuse medications. The law requires that anyone, even an involuntary committed person, has a right to refuse psychiatric medication in a non-emergency situation unless there's a judicial finding that this person lacks the capacity or ability to make rational decisions regarding his or her medical treatment. And in further response to the need for make sure that treatment is provided and people with psychiatric disability have access to treatment and maintain stability in the community, San Francisco in 2011, we started a pilot project, and that pilot project, it's called Independence in the Community Pilot Project. It's CIPP. And this is a collaboration among Department of Public Health, Office of the Public Conservator, San Francisco District Attorney as the counsel for the Public Conservator, and also Superior Court of San Francisco and Office of the Public Defender. And the key feature of this program is to have someone who has starting a serial hospitalization, and the provider identifies this person and refer this person to this program. And the program is voluntary. The person agrees not to refuse medication. They come in to check in with the judge on a regular basis, and attorney is provided to represent this patient in all proceedings. And if they feel at some point they don't need the program, they have the right to ask to leave, to be terminated. But at this point, we have 9 participants. participants participating in this program. So that's the legal system in a nutshell.
Great, thank you very much. Let's continue this discussion. Let's go to Gary Tsai. Gary, you have studied this issue from a professional standpoint and, like many people, have a personal family experience with mental health issues. As you explained to me in an email as we were putting together the panel, one of the problems here is that people with certain mental health problems may not even be aware of their condition. Give us a sense of what you mean by that.
Yeah, so there have been some studies looking at individuals with bipolar disorder as well as schizophrenia. And in these studies, about 40 to 50% had symptoms of lacking self-awareness. There's a medical term called anosognosia. And what this means is basically there's damage to certain pathways of the brain responsible for self-reflection and self-awareness. This has been shown in neurology for individuals after they've had strokes with particular areas of the brain that have been damaged. Has also been shown for individuals with dementia. And in my clinical experience, also in my personal experience with my family member, it's very clearly an issue in mental health as well. And the dilemma is that, you know, if there are individuals who are biologically unable to self-reflect and have an awareness of their illness, they oftentimes, very frequently, will not want to engage with treatment, do not see themselves as needing treatment. And this is beyond psychological denial, kind of realizing deep down that there's an issue but not wanting to accept it. It's also beyond just simple stubbornness. It's an actual inability to kind of realize that there may be something wrong. One particularly pertinent example is, in neurology for certain people after strokes where, one side of their body is paralyzed, a doctor will ask them to do a task with the paralyzed side. And, oftentimes these individuals will say that they're actually lifting their arm when clearly they're not, or come up with a reason for why they're unable to do it. So, I have arthritis in my shoulder. And so it's a big problem in mental health, and, particularly becomes problematic when there are issues of involuntary treatment being considered, and all the delicacy of that issue.
Great. Thank you. Candy Dewitt, you've gone through what must have been a parent's worst nightmare with your son's long bout with schizophrenia. He's now at Napa State Hospital after being found incompetent to stand trial for the killing of a 67-year-old man. How has your personal experience instructed your views on Laura's Law and the need for forced treatment?
My experience is that our current mental health system is based on crisis management. And from what I've seen with people like my son and people that can't recognize their illness and are unwilling to take their medication, it just does not work. Too many of our severe untreated mentally ill end up on the streets and in the criminal justice system. The pictures up here are of my son and of another mother's son. We wanted to share these with you so that you could have some kind of insight into our lives and of our son's lives. Our son could have never, ever harmed anybody in his right mind. The other mother, her son, has lived on the streets for over 4 years now. He will not see them because of distrust and the repeated calls to police from this family in hopes of getting him help. This mom told me when he was first born how beautiful he was. He was a 4.0 student. He was extremely bright and invited to all the top schools across the country. But he now lives at People's Park and on the street. Both of our families struggled desperately to get help for our sons to try to prevent this. but we could not. Our son first became ill when just after high school. He was supposed to go off to college just like many other people's kids, and then he had his first psychotic break. He went in and out of the hospital over 10, 11, or 12 times in what everybody calls the revolving door of hospitalizations. No matter what we did, we could not get any sustained help for him. When a person's left to decompensate to the point that they cannot eat because they fear their food is poisoned, or when they can't go outside because they think people are following them everywhere, when they can't sleep because they're hearing voices and because of the delusions that are in their mind, we owe it to them to intervene and help. There is nothing civil about letting somebody without their right mind decompensate to the point that they lose their lives, and sometimes other people lose their lives. A mother recently had called me and said that her son had been on the streets because he also left their house, and the police had called her first thing in the morning. She hadn't seen him in a long time. He had been living on the streets and had paranoid schizophrenia, and called them and said in the morning, your son's up at the hospital. We arrested him on a 5150. He was walking naked down the street in the middle of the night, talking to himself and people that weren't there. The mother and father jumped in the car and they went to the emergency room. And by the time they got there, the hospital had released him. I don't understand this. I'm not a lawyer, and I wasn't in the mental health field before, but I don't understand it. The qualifications and criteria for a hold are extreme, and they're unrealistic. A person must be imminently dangerous to self or other, or gravely disabled before they're picked up. If your loved one knows of a shelter place to live in other words, under a freeway, if he knows of a garbage can that he could frequent to get food, he's not gravely disabled, I've been told. If your son threatens you because his mind is telling you that you did something like poisoned his food and he's going to kill you, and the police come and pick up your son and take them to the hospital, it's unlikely that if he can present himself in a reasonable manner, which many people with mental illness can, because it has nothing to do with intelligence, he gets to the hospital and says, I'm fine, I'm not going to hurt anybody, they will release him. And this happens over and over and over again. We all know about the revolving doors. It's costly if you want to look at money, but I'm here because I'm talking about lives. I don't know. I'm just, it's very hard, and we knew nothing about mental illness before this, but I will not stop fighting for my son. I won't stop fighting for others, and I am going to scream and shout and share until somebody hears. That's all I have to say.
Thank you, Candy. Let's get another perspective on this from Eduardo Vega. You are Executive Director of the Mental Health Association of San Francisco. You've been quite forthright about your opposition to forced treatment. We've certainly had discussions with your objections to our editorials in the Chronicle in support of Laura's Law. You believe that it distracts resources and attention from the need to help the vast majority of mentally ill people who do want treatment. But aren't there cases, Eduardo, as we're hearing here today, where forced treatment is necessary?
Well, so I've been working in mental health field for about 22 years, various places across the country. I've worked in crisis programs here. I've worked in homeless outreach in New York City. I've worked in pretty much every phase of program there is. I've been a suicide prevention interventionist. And I guess after this, one thing I would say is that force is not treatment. And so the one thing that we've learned in the community mental health system, which was set up in the 60s partly to answer the need for social justice around mental health, is that people respond to dignity and fair treatment. And as an example, Dr. Tsai's discussion of anosognosia, although I think that the psychophysiology of that is still very conjectural. In a certain sense, I would say that doesn't necessarily matter. The one thing that I have realized in working with people in all sorts of states is that regardless of what you call their state, they respond to you if you treat them with love, with kindness, and compassion. And unfortunately, whether or not I think that, as an example, the Mental Health Association and generally mental health associations across the country, we do not advocate against services. But I want to point out that what is called assisted outpatient treatment, the part of that we have a concern about is actually what the technical issue of involuntary outpatient commitment. So AOT, IOC, different terms related in the model of Alora's Law program, of the 1421 programs. What we feel and that we've seen throughout the community mental health movement across the world is that the right kinds of services and supports can reach the vast majority of people, even people that are very, very ill on an ongoing basis. There are countries in which there is virtually no involuntary treatment at all, or involuntary process, and some that are very successful. So we feel that there's a lot to be done. It is true, and I totally agree with Mrs. Dewitt. We do not have out there what we need. We don't have the range of services. We don't have the range of skilled providers. And we need to do more. But do we need another process for taking away people's civil liberties when we already have one? That's the part that we have a problem with. So there is involuntary processes under 5150 under the LPS Act that were set up to protect people's civil rights. One of the concerns about the 1421, and one of the reasons that it really hasn't been implemented in many counties is because there's a lot of legal concerns, and because we're speaking to a legal audience, I just want to highlight some of those. The real issue goes to, as a matter of course, what is the process for using hospitalization as a form of enforcement? So under these 1421 programs, if someone misses a doctor's appointment, etc., they can be picked up by the police. Somebody can call them, the provider will call them, send the police to take them to the hospital for an evaluation. Now, you may say there's something sensible about that, but what we've seen in our communities is that when people's interaction with services is with the police, it's with people who want to do something to them, people who want to treat them up front as either a criminal, somebody to be wary of or suspicious of, or somebody who is sort of de facto a lesser member of society in terms of their civil rights. When people have that experience, and it doesn't matter how many psychotic symptoms they have, they push back. That's our human nature. And so what I've seen as an example in New York that's really relevant is, I remember I had this experience, and I'll leave this with you because I know I've taken a little bit of time, but I was a kind of a dewy-eyed social worker working in New York, and I was very enthusiastic about my job in a homeless outreach program. And our program was specifically to reach out to people who were very clearly ill, living on the streets in New York, and most of our domain was Central Park and Upper West Side, Harlem. And we would bring people sandwiches. So that was our outreach, initial engagement strategy, as you call it. And we developed relationships with people. But one of the things that would happen every once in a while is we would go to somebody And I remember I took out a sandwich, and they said, oh, we've seen that guy, I think his name is George. And so I go, hey, George, how you doing? Would you like a sandwich? George picks up his stuff and runs. He runs the other way. Why does he run? He runs because he's had interactions with us before, with my agency before, and with others, who the sandwich was an entry into getting them locked up, getting their rights taken away, throwing their life out of whack for 6 months. And whether or not you think that people living on the streets whether you consider that a life, those people do consider their life. So we feel that there absolutely needs to be more to provide good supports, good services for people in crisis at all levels of acuity. We do not feel that we need an conjectural and problematic extra involuntary processing in California, and certainly not in San Francisco.
Thank you. I know we're going to be hearing and discussing a lot more about outpatient mental health treatment, but let's take a moment to hear from Denny McLagan from San Diego. Tell us about the experience of San Diego's serial inebriate program. Is it working? Is the public accepting it? How are things going down there?
Let me just start, maybe for the audience, by explaining to you what the serial inebriate program does. And essentially, it is a program where people who are convicted for drunk in public 5 or more times in 30 days are actually arrested and held. And if they're convicted for the crime of drunk in public, they're offered treatment in lieu of custody time. So if you think of it like a drug court model, that's essentially how it works. And so if we want to talk about is it successful, we can throw out a number of definitions for that. We know that drunk in public arrests are down 77% in San Diego. So that's good for you. And we can talk about healthcare costs have been reduced by $73,000 a month, uncompensated healthcare, for those people who are picked up by paramedics drunk in public and transported to the hospital. So I think the hospitals think that that's good. I know from my program that 70% of the people who enter the program are successful in completing at least a 30-day stabilization program, of which 30% of those complete the entire program, graduate, and 80% are employed, and 100% are housed at the end of the program. So we think that's good. And there's serial inebriate programs now across the United States. We've gotten calls from Canada, we got a call from Ireland, and we actually have a serial inebriate program in Alaska, which begs the question, how can you be homeless in Alaska? But they are. So the interesting thing about the program, I think, for this audience is, if I were, brought to a conference for the police, we'd have a very different point of view. If I was at a conference for the district attorney, we might have a different point of view. The nice thing about the serial inebriate program is that everybody gets to do their job. The police are going to arrest people for being drunk in public, and so they like that. The district attorney is going to prosecute those cases, and the public defender is going to defend their client. And the nice thing about the program is that everybody gets to do their job. Everybody gets to do their job. They're going to do it legally, they're going to do it ethically, but we ask more that they do it morally. And so, if I'm walking down the street and I'm pulling my dog's chain, or I leave my dog outside in the cold and I don't feed it and it has health problems and I ignore it, or I dump water on it, or I kick it, or make fun of it, and I treat it harshly, he'd probably arrest me. But I can do that to a person, and everybody thinks it's okay. I don't think it's okay. And so Jeff Adachi got me on the phone and he said, I want to know more about the serial inebriate program. And I talked to him a little bit, and this is how it works. And he says, what's the biggest barrier you think to the program? And I said, to be honest with you, we sometimes struggle with having the public defender's office understand what it means to be moral and act in the best interest of their client. And he invited me here. It's like, come tell people about that. And so I'm a fan. I'm a huge fan right away, in knowing that what we need to do is make sure that those people who need help get the help that they want. And so our clients are offered treatment in lieu of custody time, And across the board, every single person that's arrested for that and sentenced and marked as a serial inebriate is offered services, and they all get help. Every single one of them, every single time, gets placed into services. And my outcomes show that they benefit from that.
Thank you. Let's go to Mr. Khan. You are a substance abuse treatment expert for the Veterans Affairs Medical Center. I understand there are some promising new treatments for chronic alcoholism that may be on the horizon. Tell us about them.
As far as treatments for alcoholism, the first thing you have to consider is how somebody gets into treatment in the first place. When it comes to substance abuse treatments, there's 4 L's that get somebody into treatment: liver, livelihood, lover, or the law. Those 4 things: liver, livelihood, lover, law. And within those L's is when somebody shows up at my door. Somebody's usually in a crisis, someone's suffering, a family member is suffering who brings somebody in. Now, when it comes to treatments, we know that there are 3 types of treatment that we do in addiction. There's evidence-based treatment. There's good evidence for it, we do it. There's evidence-free treatments. There's certain treatments that we do that have no evidence or assessments on it whatsoever. And then there's evidence-proof treatment. I don't care how good the evidence is, we're going to do it anyway. One of those forms of evidence-proof treatment is incarceration treatment. There was an Office Inspector General report on the CDC in 2009, and eventually Matt Cate became the director of the CDC, that showed that in-custody treatment within the CDC had worse outcomes than if people got no treatment whatsoever. Now, I can't say that's necessarily true at the San Francisco jail system. I think we have some very progressive programs here. I've been involved with some of them through the behavioral health court and other places. But treatment in custody doesn't work. Flash incarceration does not work. So as far as the treatments that do work for alcoholism, alcoholism is a chronic disease. It's a chronic disease like diabetes, hypertension, and emphysema. And when we look at outcomes for chronic disease, a landmark study published in the Journal of the American Medical Association in 1999 showed that the results for treatment were no worse or no better than any other chronic disease model. So treatment of alcoholism works. Treatment of addiction works. They looked at all of those things. As far as promising new treatments for alcoholism, when it comes to substance abuse treatment, typically with any chronic disease, it takes time and it takes effort. And let me offer the picture of 2 extremes. One extreme is the first of the month with $200 in your pocket and you're in the Tenderloin and you're addicted. The other extreme is a stationary object and handcuffs. With a stationary object and handcuffs, you won't use. But if you've got $200 in your pocket, you're addicted in Tenderloin, you're definitely going to use. And so the illustration here is that somewhere between these 2 extremes, there's a level of treatment structure that is appropriate for the particular patient. When we think about the patients who end up revolving through the court system, the chronic public inebriates, what we see is a picture of people with genetically loaded illness, trauma histories, they've had bad lives, bad things that have happened to them. They have no supports, and none of those 4 L's, they may have some of them marked off, but they've got no lover to support them, they've got no livelihood to live for. And so what you need to do is you need to provide an adequate amount of support to help somebody achieve the goals that they want. Now, notice I don't say sobriety. I'm a substance abuse expert who doesn't believe in sobriety. The reason being is that sobriety may not be a realistic goal for people. The realistic goal, and this may be some of the innovations in treatment, is expecting somebody, okay, what are we going to work on here? I want to stop being arrested by the cops. Good, that's a good goal. How do we achieve that? I want a roof over my head, and oftentimes people don't say that. Good, how are we going to achieve that goal? Now, I believe sobriety is a form of harm reduction as we know it, and sobriety has relatively few side effects compared to some of the other stuff that we have. And it tends to be the best way, but it's not the only way. And so when it comes to moving forward and thinking about treatment, I think we need to move from a sobriety-centered model to a patient-centered model when we're interacting with the legal system with somebody who's being shoehorned into treatment. The fact of the matter is, I love patients who've been shoehorned into treatment because they do just as well as anyone else. I've not yet to have a patient walk in my door and say, "Doc, I need treatment." What's wrong? I use cocaine. What's the problem? Well, my wife loves me, I'm doing great at work, and my kids are doing awesome. I've not had that happen once, and I've seen thousands of patients. There are exciting medications on the horizon. I won't bore you with the particular details, but there are potential medications that may look into, that may offer some promise for managing, again, managing, not treating, managing chronic alcoholism. I know that the city and county is actively pursuing some of those medications. They're expensive, that's one of the barriers to getting them, but at the same time, if I can offer somebody an injection that says perhaps you may not be a drunk as much anymore, most people will at least think about giving it a try. There are various types of treatment protocols that are coming out. Those things also show promise as well. But in the end, it has to do with time and effort. And those are the things that really, there's nothing new in addiction that is that magical, that will change the face of what it is that I do.
Great, thank you. And last but certainly not least in our opening remarks, we want to hear from Greg Suhr, the Chief of Police in San Francisco, because Chief, like it or not, your officers end up in the front lines of dealing with untreated mental illness or substance abuse issues. What's working out there? What's not working? And does the law as it's applied or allowed in San Francisco give you the tools that your officers need to do the job?
Thanks, Sean. It's kind of ironic that I'm going last because, as John said, we're first in dealing with people in crisis and of severe diminished capacity. I can remember back when I was brand new, back in 1981, there were folks in alleyways. One strike comes to mind. His name was Bobby Dunce, and you wouldn't even recognize him from the time you would initially contact him to the time that he would get out after a 90-day hold for court. We don't have that anymore. There are people in the audience that might remember it. Jeff might, actually. But the answer can't be to do nothing. So as police officers here in San Francisco, there's a myriad of options that the officers go through, whether it's 5150 for people in crisis, danger to themselves, danger to others, whether it's going to mobile assistance program, sobriety center, door alley. I know there's some mental health professionals who work closely here with our CIT program. We're trying not to get folks into custody. Dr. McLagan put up, that when we arrest drunks, we like that. No, we don't. If you've ever arrested a drunk, it's no fun arresting a drunk, right? To varying degrees, and there's a huge range. But again, we're the city of San Francisco. We have to do something. When you have people laying in circumstance that's sometimes unimaginable, and they can't make a call. They can't self-select. It goes back to what Mrs. Dewitt was saying. They would help themselves if they could, but they can't. So in talking about the San Diego SIP program, which I know our mayor is in favor of, and we're going to be trying to do here in the city, and we're with Officers Rich and John from San Diego who, talk about their place in heaven is assured, the work that these two do with Dr. McLagan. But if we can get it going, the object is to just get the person to stop putting the poison in their system. And if you can't get them to select treatment, it's all treatment, Deni, take. But at some point in time, if you can't pick, then you do get 30 days in jail, but you have to pick it, or it gets picked for you if you can't pick. And on the high side, even though jail isn't something we want to talk about for people that are in crisis, the poison doesn't go in their arm, the poison doesn't go in their mouth, they get medically cleaned up, they get deloused, so there's no stuff, they get clean clothes, And that was sort of the instance with Bobby Dunce. Yeah, we didn't have the programs and services that we have now in 81, but when he would come out, you wouldn't even recognize him. And within about 2 or 3 weeks, he'd find his way to being a trustee in the jails, and you'd go see him when you were putting more serious criminals in jail for real criminal violations versus these are just holding periods to get the person a break, if you will, from harming themselves, maybe to get them to a point where they could select some of the options that are available to here up on the table. And we're not talking about months and years. It is literally, it takes almost an act of God in San Francisco to get a conservatorship on somebody. It was raised earlier. I'm telling you, it just does not happen in San Francisco. And there are people in San Francisco that desperately need to be in conservatorship, but we don't do it here in San Francisco, and we should. It's the kind thing to do. It's the compassionate thing to do for some people that are at that state of crisis that they are going to harm themselves or someone else. I will tell you, looking at this crowd, I don't think there's a lot of people in here in support of the death penalty, and that's the penalty that you're sentencing these folks to.
Yep.
Thank you. Our panelists have really given us a terrific overview of differing perspectives on this, and we're going to get to audience questions in just a few minutes. So go ahead and fill out your cards, and we'll get to you momentarily. But let me start by opening up the discussion. You can really see the conflict of perspectives here on forced treatment. And I want to start with you, Kenny DeWitt, and ask you about some of the points that Eduardo Vega made about his opinion that force is not treatment, that basically that the key is to approach people with mental illness with love, kindness, and compassion. I know from our editorial page, when we've written about Laura's Law, some of the most poignant, compelling arguments that we've got from it have come from letters from family members who have done just about everything they can do in terms of love, kindness, and compassion. Hasn't worked. They want to help their loved ones. What's your perspective on looking back with your son? Could forced treatment have made a difference?
Oh, yeah, absolutely. And Laura's Law is not forced treatment. And I don't know why Mr. Vega keeps using that word, because Laura's Law is an upfront tool before somebody becomes in crisis to try to help them. If somebody's been repeatedly hospitalized over and over again, if they've proven to be a danger to themselves or someone else, a judge tries to get together with him and a treatment team, and they try to talk with this person and figure out a way for them to stay out of the hospital. We have forced treatment. We have 5150s. My son has been through 5150s time and time again. He's been slammed into the psychiatric hospital, slammed with psychotropic medications, and it is a horrible experience. That's what we're trying to avoid. Laura's Law is a tool, only a tool that may help. And for whoever can help, thank God they don't have to go through the other part. I would say the same thing as this officer said, is that some people cannot help themselves. It is not civil to sit here and watch people lose their lives. I can tell you that. I have been in groups for 4.5 years. I have heard many family members. Their children are losing their lives. Families are in severe stress. We have to find something else, not our 5150s, not our 5250s. They don't work. That's when we're forcing treatment, but we're waiting till people are in crisis before we do it.
Let's go back. Eduardo, I want to give you a chance to elaborate. Earlier we heard from Gary Tsai, who was saying basically that one of the very symptoms of certain illnesses is inability to recognize that you are mentally ill. What do you do about people in those situations where no matter how gentle, no matter how sensitive your approach, they don't think they're sick?
Well, let me reframe it just a little bit, if you don't mind. What do you do about, if I asked you if you're mentally ill and you say no, and that actually becomes a way of diagnosing you as mentally ill, doesn't that present a whole lot of problems? People, and that actually is one of the things that I think is most concerning. Now, obviously there are people who are very ill, and there's also there is a lot of debate about the terms that we use for psychiatric illness. Now, if you tell me, okay, Eduardo, you have this diagnosis, and if you don't believe that you have that diagnosis, that actually is reinforcing my belief that you have this diagnosis. That's pretty problematic. And you can see that really the issue, I think the reason this is interesting is because it tracks back to the really big issue when you talk about social justice and mental health, which is what is the responsibility of society to provide services and supports for psychiatric illness? If we want to ask that question, we should ask, what is the rate at which we fund services and supports for mental illness? What are the range of services that we provide? The questions about whether or not somebody agrees to your diagnosis, and as a matter of course, your average person who's in the system for several times will receive between 3 and 5 different diagnoses over time. So, without getting too technical, I think that the issues really are broader, and that's what this panel is interesting about, which we have to ask ourselves: do we believe that as our society, our role is to take people's choice and freedom away from them under certain circumstances? Or is our role as a society to support and provide what we can do the best? No solution, I would posit. There's no perfect answer. We already have involuntary processes, and we already have services. We can do a lot better. But the real question to me is more interaction around people's lives that revolves around authority taking control of their lives. Is that really going to produce the results we want as a society?
We're going to go to audience questions in just a second, but I want to make sure that Gary Tsai has a chance to weigh in on this question as a psychiatrist. I mean, how do you distinguish between somebody who, when they're asked, is mentally ill, says no, and then that is used against them, as Eduardo suggests?
Yeah, I think, I want to start off by talking a little bit about why I'm interested in this issue. As I mentioned earlier, and John mentioned earlier, I have a family member, my mother actually, has had schizophrenia ever since I was very, very young. And, we went through some of the same heartache that I think Candy Dewitt describes in terms of trying to get her into treatment, bringing her to the hospital, having her present very well, having her discharged, police getting involved eventually, simply for just being psychotic in a public area. Having to travel and go to court hearings, a very messy issue. The reason why I'm interested in this particular issue is not because I'm interested in controversy or particularly polarizing issues, but because I believe in it. I believe that Laura's Law assisted outpatient treatment is a tool among many tools that we have in the mental health system to try to engage people in a recovery-based way. The foundation of Laura's Law is a multidisciplinary team trying to engage people, trying to give them as much say in the treatment plan as they're willing to provide. And when you read the description at Nevada County, the only county that has it fully implemented in California, and when you meet the individuals who work there, they work there and do the work they're doing because they believe in the same things I think that Mr. Vega was mentioning, love, kindness. I think that's why we all do this work. But I think there are individuals like my mother, maybe like Ms. DeWitt's son, who need a little extra help. And I think that oftentimes, clients see judges differently than they see their doctors. They're more likely to listen to judges than they are to doctors. And that can be a very effective push into treatment, and that, you know, sometimes not pushing them in that way actually prevents them from getting into treatment to begin with. I mean, oftentimes what I've found is that that is the first step to recovery. Once they're engaged in treatment, then they can, you know, continue to receive treatment voluntarily, but that sometimes some individuals need a little extra help. And that's how I see, and actually one thing that I think it's also important to distinguish between, you know, making diagnoses. I think that the diagnosis of schizophrenia or bipolar is very clearly stated, and the fact whether or not someone has insight into their illness or not isn't factored into the diagnostic criteria, just to make that clear as well.
Great, thank you. We have an audience.
I agree with that. I do know that that's the case. I was talking more.
Plotting an audience question, I guess. We have an audience question for Eduardo Vega. For the severely mentally ill, involuntary measures in current usage are both chaotic and traumatic. Emergency room and jail, we heard Candy Dewitt and Greg Suhr both talk about how the current systems work. On the other hand, Laura's Law provides community-based support services with no forced meds. Why would you oppose this kind of gentler intervention?
Very good question. And it also goes to the question I think that you brought to the panel at the beginning, so a very useful one, which is why has Laura's Law only been implemented in one small rural county? So I think that part of the answer is we do have good community services and supports in San Francisco and in California. We actually have some of the best in the country, and they're funded, incidentally, through the Mental Health Services Act. Do those services solve everybody's problems all the time? Absolutely not. Do we need more of them? Absolutely. But the issue of bringing an additional court process that threatens people with enforcement measures and that takes away rights of self-determination, I think is sort of at the core of what our opposition to it. Now, Gary pointed out, I think very validly, that the program, I know the people that run the program in Nevada County, the program that provides us services, that program is available to people voluntarily. And in fact, I want to point out that only 4 people have actually been treated through the involuntary clause in Nevada County. Now, those services are available to a whole range of people, and 4 people in the last 10 years, maybe it's changed since the last year since the report came out, but 4 people were involuntarily mandated to those services. A couple of them succeeded, a couple of them didn't. The point is, that's a county where you've got a chief of police who meets with the judge, who meets with the Department of Mental Health, or the head of the Department of Mental Health, at breakfast in their local coffee place. That model can work, maybe interestingly, in a small community where you're going to know the clients, you're going to know the people that come up. Does it work in an urban setting where you've got a highly complex and structured system or interaction of systems between police, between providers and things like that? We don't think so, and that's actually a lot of the reason that it hasn't been implemented. It's filled with all sorts of legal problems, and then you've got the coordination problems of bringing additional court systems into alignment, using hospitals as enforcement measures and things like that. So, so there are good treatment and there are good services out there, but we need more of them, and we need better than we do have. I totally agree with that.
This is obviously an extremely important discussion, and one that I suspect is going to continue not only here in San Francisco but throughout the state and nation. And I really, please join me. Unfortunately, we've run out of time, but I want to thank our panelists for really laying out and framing this issue as they did. Thank you very much.
Well, and you yesterday made a